A Fox News alert: the U.S. Supreme Court will consider a legal challenge to the new health care law passed last year. Opponents of that law say it oversteps the boundaries of government power. Bill McCollum is the former Attorney General of Florida. His case is the one being considered by the High Court. And General McCollum, good to see you. I know you're pleased about this because they took your case, but you had a big setback last week when two very conservative judges on the D.C. Court of Appeals upheld the individual mandate. How worried are you that that may influence the High Court against your position?
Well, obviously, there are several decisions that have been made, and judges have come out different ways in the lower courts. We won both in our federal district court, and we won in the 11th Circuit Court of Appeals with a Democrat-appointed, Clinton-appointed judge going our way, saying that it is unconstitutional. Judge Silberman last week ruled that it was. The other judge didn't actually rule that it was constitutional. He simply said that he didn't think it should be decided right now, that we should postpone this till 2014. So there are a lot of variations in here as far as the way these judges have ruled. What I think is important about it,
if I may, let me put, you mentioned Judge Silberman, and so let me put up on the screen his reasoning in upholding the mandate. Quote, "The right to be free from federal regulation is not absolute and yields to the imperative that Congress be free to forge national solutions to national problems, no matter how local or seemingly passive their individual origins." Look, General McCollum, since healthcare is about 20% of the U.S. economy, it clearly impacts interstate commerce. So on that basis, isn't Judge Silberman right? Congress has the authority to regulate.
No, I don't think he is. But, of course, that's what the justices are going to decide next June after oral arguments and briefings and so on. The real issue here is whether in the individual mandate that requires you or I to buy a health insurance policy or pay a penalty, whether the Commerce Clause, which is what this is all being decided under, does it have any limitations? How far does it go? Can you passively, he used the word passive, no matter how passive. Most judges I know wouldn't begin to go that far. In fact, the Supreme Court has ruled in other cases recently that there is a limitation. There are limiting principles to the extent to which the Interstate Commerce Clause can go. The Justice Department's argument is the Silberman argument. He just bought it. He just simply said, look, it's so big, healthcare is so large that we're going to have to let this go. It's not unique, though. Healthcare is not unique. You've got, if you want to talk about cost shifting, which is really the argument in the Justice Department's case, and the impact of you're not buying a health insurance policy on everybody else, you've got people who don't pay their debt and their credit card debt that impacts everybody else.
But look, you mentioned Supreme Court cases. There is precedent, and you're familiar with these two cases, the Wickard case and the Gonzalez case, which was a recent one, which the High Court affirmed the right of Congress to regulate even personal activity if in the aggregate it has an impact on interstate commerce. Doesn't the fact that there are millions of Americans who go uninsured, doesn't that impact healthcare costs and thus commerce?
Well, in theory, of course it does. I mean, everything you do is economic activity, just about. But it's a question of, are you active? We've never had a Supreme Court ruling in the past, never, where the Congress was determined to be able, under the Constitution, to require somebody to buy a product or a service. That's very unique in this case, and a very unsettling extension, if they do extend it, of the Commerce Clause. In addition, you and I can sit here and list together, as I started to do, and I'm certainly not going to list all of them, literally hundreds of ways in which passive inactivity would impact the economy.
Well,
but is it right under the Constitution for everybody to be able to do that? And then the other big question in the Florida case, not decided and not in any other cases, is whether or not the Medicare provisions in here, the Medicaid provision, I should say, are constitutional either. Are they couring the states? Are they going beyond the powers of the 10th Amendment? That's going to be heard too.
If the court is divided in Anthony Kennedy's The Swing, his former clerk, who is now a law professor at George Washington, Orrin Kerr, says he thinks, based on Kennedy's past writings, he's going to side with Congress and the president on this. We'll just have to wait and see. Bill McCollum, former Attorney General of Florida, congratulations. They took your case, and I know you're optimistic.
We're glad they did. Thank you.
Bye-bye.